Our topic today is voluntary administration. So we're still looking at companies in financial distress. So in this podcast, we're going to consider what voluntary administration is and also how an administrator is appointed. So the voluntary administration provisions in the Corporations Act are a fairly recent introduction, and they have proved exceedingly popular. So we've spoken a lot in the unit about the benefits of incorporation, the rights of members, the interests of creditors, and the obligations of various officers of the company. So you should have some appreciation by now of how the rise of the limited liability company, hot on the heels of the Industrial Revolution, focused quite considerably on ensuring confidence in investing in companies, as well as the protections afforded to entrepreneurs by both that concept of limited liability and the notion of the separate legal entity, which we've talked about. There is accordingly some risks for creditors dealing with companies, and we have looked at how creditors minimize those risks themselves, and also how the Corporations Act supports the interests of creditors in some circumstances. So the delicate balance that is struck by the Corporations Act is for the purpose of facilitating business and investor confidence, because both are vital to our economy. So the OECD is adamant that quite possibly the key driver of wealth and employment is small to medium enterprise. And as we've witnessed, these enterprises make up the bulk of registered companies in Australia. So these notions are all reflected in ASIC's objectives as our corporate regulator. Its goals are to support confident and informed investors, to foster fair and efficient markets, and also efficient regulation and licensing. So every one of these factors is important because it has, of course, a bearing on our economy. So it's really not surprising that the insolvency law regime that we have, which is there largely to protect the interests of creditors, is really perceived as playing a key role in the Australian economy. So to give you some idea of its importance, I want you to consider the statement from the explanatory memoranda that's up on the PowerPoint. So this was to the 2007 Corporations Amendment Insolvency Bill, so the second reading speech. I am going to be talking to you about some most recent updates as well today. So Australia's corporate insolvency regime is a critical part of our economic infrastructure. Insolvency law underpins the system of financial and contractual relationships that enable trade and commerce to take place. A modern credit-based economy needs predictable, transparent and affordable means for enforcing secured and unsecured credit claims. A well-designed insolvency system helps business to obtain financing more easily and, of course, at a low cost. Insolvency laws and processes also complement the general body of rules governing directors' duties, as they provide a set of incentives and sanctions that guide the behaviour of directors during the life of the company. And you've already looked at all of that this semester. Okay, so in order to contextualise the law that we're going to be covering this week, we do need to be clear on a few basic principles. We need to recognise that we're looking closely here at an insolvency situation. So the starting point for us is to understand Section 95, capital A of the Corporations Act. So that section simply says, if you go and have a look at it, you'll see it says a person is solvent if, or a person could be a company, of course. A company is solvent if and only if the person or company is able to pay all of its debts as and when they become due and payable. And subsection 2 says a person who is not solvent is insolvent. So when you look at that section, you'll see the word person is used, but we know that a company is a legal person. Okay, so consequences of insolvency include insolvent trading, which you've already talked about this semester, receivership, voluntary administration, which we're looking at this week, and also the possibility of liquidation, which we look at next week. So voluntary administration is a very popular form of external administration. So it's a very popular form of external administration. It's cheap, relatively easy to initiate. It doesn't typically involve the court, and it can be very valuable if there's any prospect of the company being able to trade out of its financial distress. So this makes it an excellent alternative to immediate liquidation, which we'll look at next week. So remember, voluntary administration is what we call a form of external administration. Someone's coming in from outside, that is here the administrator, and they're administering the company's affairs with a view to something in particular. So we're specifically talking about here an opportunity for the company to trade out of its financial distress. So that's what voluntary administration is affording. It is best used when at least one part of the company's business remains viable. This is a key point, despite the company's financial distress more generally. So if the provisions in the Act, and I'll refer to rules and a schedule of the Act as well because of some amendments. So if these provisions didn't exist, then we would need to move almost immediately to winding up in insolvency or some other form of administration. Now, if you were to move almost immediately to winding up in insolvency, then it may not be to the benefit of the company's members and the creditors, especially employees. So voluntary administration offers at least some hope where it is possible that the company could trade out of its financial distress. So let's start by looking at what voluntary administration is. It is an entirely statutory process. Now, until recently, it was all contained in Part 5.3 capital A of the Corporations Act, and we still need to start there. So Part 5.3 capital A. But we had the Insolvency Law Reform Act passed in 2016, and it introduced a raft of amendments. So now what we find is some of the sections contained in 5.3 capital A of the Corporations Act have in fact been moved into, or sometimes slightly changed, into Schedule 2 of the Corporations Act and also into the Insolvency Practice Rules Corporations of 2016. So I've put that as our final bolded note on your PowerPoint. So now what we need to do is we need to look at Part 5.3 capital A as well as Schedule 2 of the Corporations Act as well as the Insolvency Practice Rules Corporations of 2016. So these recent amendments unfortunately do complicate this for us. So it's not all contained in Part 5.3 capital A now. Okay, so what voluntary administration does is it allows for the administrator, so the person who's external coming in, it allows for the administrator to take over the company's affairs with the object of entering into an arrangement with the company's creditors. Now that arrangement is called a deed of company arrangement, which is traditionally abbreviated as a DOCA or a DOCA. So you'll hear that a lot. So it's through this arrangement that the company will hopefully be restored to financial health and be able to continue trading. But if it doesn't work, the company will then be placed into liquidation, which we look at next week. So I put the objects of Part 5.3 capital A on your PowerPoint for you. So it's so that the company's affairs are administered in a way that maximizes the chances of the company continuing in existence, or if that's not possible for the company to continue in existence, the voluntary administration process, the objective is that it results in a better return for the company's creditors and members than would result from an immediate winding up of the company. Now the court interprets the sections in this part by actually and also the practice rules that we'll look at, and now also the Schedule 2 of the Corporations Act. It interprets them looking at these objectives. Okay, so it's important that you understand reforms contained within the Insolvency Law Reform Act of 2016 have been staggered in their implementation. So some of these changes came into effect in March of 2017 and others in September of 2017. So what this means is that you need to keep that in mind, and I want you to focus in on what I've updated here on these podcasts. So we're looking at Part 5.3 capital A, Schedule 2 of the Corporations Act, and the Insolvency Practice Rules, Corporations 2016 now. So the law is now contained in those three places, not just in Part 5.3 capital A. And everything we're talking about has come into effect. So the reforms brought into effect that have been incorporated into Schedule 2 and into the Insolvency Practice Rules came into effect in both March 2017 and also September 2017. Okay, so despite the use of the term voluntary in voluntary administration, it is possible for an administration to be initiated by a substantial secured creditor against the company's own wishes. So in this sense, the administration is voluntary from the perspective of the creditors, but it might not be from the perspective of the company. So you've already looked at Section 588 capital G, trading whilst insolvent. If at a meeting of a board of directors, the company was deciding whether or not to enter into a certain transaction, and during the meeting concerns were raised as to whether or not entering into that transaction may stretch the company's solvency situation into something quite precarious, and genuine concerns were raised about the solvency of the company, then clearly directors seeking to do this and to do the right thing should stop trading until they're certain that they're not risking personal liability under Section 588 capital G. So you've already learnt about that. Now, one way they could do this is if they resolve to put the company into voluntary administration, and the administrator would immediately see what could be done to try to enable the company to trade out of its financial distress, with arrangements being put into place with the company's creditors. Okay. Now, this is a brief summary of the principal features of the voluntary administration scheme. So first of all, the administrator takes control and investigates the company's affairs. During the administration period, there is what's called a moratorium on claims against the company by creditors, and we'll talk about that later. The administrator, under pressure of time, there's lots of time limitations, must convene 2 meetings of the creditors. And it is the second meeting that's most important, because it's at this meeting that the creditors will decide what the company's future will be. So the possible resolutions are: 1, to execute a deed of company arrangement, so a DOCA, or 2, to end the administration, which essentially just means to put the company back into the position it was in prior to the commencement of the voluntary administration. So this by no means solves the company's financial distress in any way. And the third option is to resolve to wind up the company by winding up in insolvency. So ultimately, what you can see there is that voluntary administration puts the creditors of the company in a position where they decide the company's future. So keep that in mind, and keep those 3 options in mind, because we will talk about those this week. So for this topic, you're about to see that we're going to be referring to Part 5.3, Capital A, Schedule 2 of the Corporations Act and the Insolvency Practice Rules in detail. So voluntary administration is entirely a creature of statute. There is a strict focus on timelines because the policy of the legislation is to expedite the process, and the process is conducted between the administrator and the company's creditors. And these parties need to meet very short deadlines. Okay, so how does an administration commence? It all begins with the appointment of an administrator, and the administrator can be appointed in one of 3 ways. So the first is that the company can do this by a resolution of the company's board. So that's Board of Directors, Section 436, Capital A. I'm going to want you to refer to all the sections in your own time that I refer to here to really understand this topic well. So the board has to be of the view that the company is either insolvent or is likely to become insolvent at some point in the future, and that an administrator should be appointed. So why might the directors do this? Well, we've talked about Section 588 Capital G already. Okay, so there's a raft of consequences that flow from insolvent trading that you already know about. Okay, just another point. If the administrator isn't properly appointed, the appointment can be set aside by the court under Section 447 Capital A. But the court would need to be satisfied in this context that the appointment was for an improper purpose, and if the appointment was for an improper purpose, that would then trigger the issues of corporate governance that you looked at earlier in the semester, that directors need to exercise their powers in good faith for proper purpose, etc. So there are some limits on a company's power to appoint an administrator by way of resolution of the board. The first is that the board cannot appoint an administrator if the company is already being wound up or is in provisional liquidation, Section 436 Capital A. This is the most common way of appointing a liquidator. Okay, the second way that voluntary administration can commence is through the appointment of an administrator by a liquidator or the provisional liquidator. And this is done under Section 436 Capital B. So there are links between this week's topic and next week's topic, and you'll see that as you do the content for both. So the liquidator or provisional liquidator can only appoint themselves with the leave of the court or if at a meeting of the company's creditor, the company passes a resolution appointing the liquidator. Section 436, capital B, subsection 2. So the liquidator must be of the view that the company is insolvent or likely to become insolvent. There are a couple of relevant cases on your PowerPoint slide. The one that I would like to refer you to is Re-Despin Proprietary Limited, the 1994 case, which suggests that a strict approach ought to be taken here, particularly in relation to who can be appointed as the administrator. So the court pays particular regard to the administrator's independence because the interests that a liquidator must protect could conflict with an administrator's duties. Okay. The third way that an administration can commence is by the appointment of an administrator by a secured creditor. And this can only be done by the holder of a security interest in whole or substantially the whole of the company's property. So the relevant provision here is section 436, capital C. Okay, so the security interest that the creditor holds has to be valid and enforceable, and there's no definition of what constitutes the whole or substantially the whole of the company's property. But there's no doubt that this definition includes PPSA retention of title property. So of the three different ways that administration can commence, about 90% of voluntary administrations are initiated by that first option. So that is by resolution of the board, and the balance are mostly initiated by liquidators. So this third option is the least common option. So if a creditor finds themselves in a position where they would need to make a strategic decision about appointing a receiver or a voluntary administrator, that's when this can occur, but most often they would appoint a receiver. So statistics show that the appointment of an administrator seems to be a less popular option. Okay, so who can be an administrator? An administrator must be a registered liquidator, section 448 capital B, and not connected with the company in any material way, section 448 capital C, unless they have the leave of the court. So what would amount to a material connection? The legislation does provide some stipulations to assist us with this, but I'm not going to go into detail about that for this particular unit. It's beyond the scope. Okay, so there are a number of circumstances that can disqualify a person from being an administrator. One, I just referred to, the administrator must not be connected with the company in a material way, section 448 capital C. So if you have a circumstance where the administrator is connected in a material way, then that person needs the leave of the court to be appointed and acted as the administrator or of the deed of company arrangement, so the DOCA, and that's provided for in section 448 capital C subsection 1. And you would be connected in a material way if you were, for example, a director, secretary, senior manager, employee of the company, or an auditor of the company. Now, an administrator must make a declaration of any relevant relationships in the last 2 years and a declaration of any indemnities that they have taken pertaining to them taking up the role of administrator, and this is set out in section 436 capital D capital A. So an administrator can also be disqualified for lacking independence over and above any material connection. So when we look at liquidators next week, you'll see that the issues around independence are similar. So the law is crafted in a way to not only ensure that the liquidator or the administrator is independent, but also that they're seen or perceived to be independent. Another important point is that the administrator being appointed must have consented in writing to their appointment and must not have withdrawn their consent, section 448 capital A. So once they've been appointed, their appointment cannot be revoked, section 449 capital A. Okay. On this point, we also need to go and have a look at Division 90 of Schedule 2 of the Corporations Act. So this is one of those amendments that was brought in under the Act that I meant, the 2016 Act that I pointed out earlier. So under Division 90, Schedule 2, the court may inquire into the external administration of a company, either on its own initiative or on the application of the company, the external administrator, ASIC, or a person with a financial interest in the external administration of the company. And when you look at that division, you'll see that the court has wide powers to make orders, including orders replacing the external administrator or dealing with losses resulting from a breach of duty by an external administrator. Now also under section 449 capital C subsection 6 of the Corporations Act, you'll see that where a company is under administration but for some reason no administrator is acting, the court may appoint a person as administrator on the application of ASIC or the application of an officer, member, or creditor of the company. And also note that the court has powers under section 447 capital C to declare an appointment valid or invalid. Note also that the power under that section, under section 447 capital A includes the power to make a variety of orders that could include to end the administration. So sorry, I know I'm jumping around a little bit from the Corporations Act to the schedule now, but unfortunately that's now the way the law's crafted. So as soon as the administrator is appointed, the administration begins. So given how important the time provisions are, this is a very important date. So time starts to run from that date. There are a number of notices that must be sent. The first of these is set out in section 450 capital A. So notice must be sent to ASIC on the next business day after the administrator's appointment. Okay, so the appointment must also be advertised on ASIC's insolvency website. Above this, the company also needs to begin referring to itself as a company under administration. In every public document and every negotiable instrument, and wherever the company's name appears. So the company indicates this by putting it after its name. So they write administrator appointed after its name. And that's provided for in section 450 capital E subsection 1. So the first notice required is the notice to ASIC. There are other notices that might be required that turn upon who made the appointment of the administrator. So if the administrator's appointment was at third category, so by the holder of a security interest, then they must notify the company itself of the appointment before the end of the next business day. This is obviously necessary so that the company knows that they're actually in administration. If the creditor is appointing an administrator because they believe that the company is insolvent, then the directors also should be contemplating contemplating the solvency situation and ceasing to trade, and determining how to proceed. So it's important that the company is given this notice, as it will affect the company's decision making. If the appointment was made by a liquidator, then the notice needs to be given to any security holder who has security over the whole or substantially the whole of the company's property. And this notice must also be given on the first business day following the administrator's appointment. This again makes sense because this kind of secured creditor is entitled to either appoint a receiver or most definitely appoint an administrator in its own right. So these notice provisions are not, these notice provisions are not complied with, it doesn't necessarily affect the validity of anything that has happened unless the court orders otherwise. So have a look at section 50 capital F. So it's saying a contravention of these notice requirements does not affect the validity of things that happen after, that flow after the appointment and the notice, unless the court orders otherwise. Okay, so thank you for listening to this podcast. When you're ready, you can move on to the next.